Good morning to everyone. Madam Registrar, kindly open the proceedings.
Thank you, Madam President. Hearing of the 14th Annual Caribbean Court of Justice International Law Moot in the matter of Moot 001 of 2024 between TT Distributors and the Republic of Trinbago. The members of this morning's panel are Madam Justice Rajnath Lee, President and Presiding Judge, Mr. Justice Barrow, and Mr. Justice Jamada. May we have the appearances, please?
Good morning, Your Honors. From the University of Guyana, representing the claimant, TT Distributors, Shanae Bash, Senior Counsel, Crystal Dukey, Junior Counsel, and Christine Richardson, Researcher.
Thank you.
Good morning, Your Honors. Giroy Derby, Senior Counsel representing the Republic of Trinbago, Junior Counsel, Ms. Edith Linfeld, and our researcher is Ms. Ferry Boomgaard.
Thank you very much to both teams. Ms. Bash, are you ready on behalf of the University of Guyana?
Yes, Your Honor.
Very well. And you represent TT Distributors Limited?
Yes,
thank you. Please come to the podium. Is there anyone assisting you who will come as well? Thank you. You may begin. Thank you.
May it please this court. My name is Shanae Bash, once again, Senior Counsel for the claimant, TT Distributors. I will be making two substantive submissions for the court today. One, that the actions and inactions of the defendant Trinbago substantially impaired TT Distributors' right of establishment under Article 32 of the Revised Treaty of Chatham, herein referred to as the RTC. And two, that the actions and inactions of the defendant Trinbago frustrated the benefits TT Distributors are entitled to, TT Distributors' goods are entitled to, as community origin goods under Articles 82 to 84 of the RTC. Hereinafter, our junior counsel will make submissions on whether Trinbago's inactions frustrate TT Distributors' right to the free movement of goods under Article 91 of the RTC. Your Honors, with your permission, I will begin my substantive submission.
Very well. Thank you.
Your Honors, we submit that the defendant Trinbago has substantially impaired TT Distributors' right of establishment under Article 32(3)(1)(b) of the RTC because their refusal to honor the 40% CET discriminated against TT's distributor and created a financial burden. The right of establishment allows for the creation and staffing of companies in other Caribbean jurisdictions, and it only applies to nationals of other member states. So under Article 32, citizenship is a pivotal aspect of the RTC. TT Distributors, being a national of a member state, is entitled to the right of establishment outlined in Article 35(a)(3) specifically. The conditions for a company to be regarded as a national of a member state are listed in Articles 32(5)(c) and include substantial ownership and effective control. With Mr. and Mrs. Hassan owning 55% of TT Distributors shares and being nationals of Dominica through the Citizenship by Investment Program, the conditions of substantial ownership and effective control are satisfied. The defendants contend that the Hassans are ineligible for Dominican citizenship. However, the courts must apply a presumption of regularity to the conferral of their certificates of naturalization. The presumption of regularity is a legal principle that assumes that all government actions are conducted lawfully unless there is evidence proving otherwise. In paragraph 23 of Gobin and another against the AG, the court applied this foundational principle and stated that in the absence of proof otherwise, the court must assume that the orders were validly issued. As such, the Hassan citizenship is presumed to be validly issued unless there is evidence otherwise. And in this case, there is no such evidence.
Excuse me.
Yes, Your Honor.
Are you conceding that they are entitled to raise this question? as to the validity of the nationality or the,
No, Your Honor,
citizenship?
I'm simply responding.
But you have not taken the objection that they should not.
Well, Your Honor, I truly believe that a citizenship is not something that should be contested in this case, as per the laws of.
I am glad I asked you because you had not said so.
Oh, well, Your Honor, I apologize for that, but I truly do believe that the citizenship should not be contested.
Yeah,
Thank you.
Miss Bash, I wanted to ask you a little different question, though. I don't know if you're going to come to it, but if you are, you can come to it now then. You have brought an application under Article 222 as a private entity seeking leave for special leave to commence a claim against Trinbago. Is that right?
Yes, Your Honor.
What is the test for 222 as far as locus is concerned?
Your Honor, my junior counsel will be the one dealing
Oh.
with this matter.
Okay, but I trust that your junior counsel then will tie in what you are saying to 222. Yes, so you've not looked at that at all.
Not in my submission, Your Honor.
Okay, thank you.
Ms. Bash, permit me just the observation. If that is a logically precedent point, then surely it is a point which should be dealt with at the beginning of the submissions. I know you have organized it as you have, so I'm not chastising you for it, but I'm just making the comment that as a matter of order and logic, it is you who should be dealing with it. But do continue.
Thank you, Your Honor. Guided. The defendants contend, my apologies. I will move on from the matter of citizenship as we have all agreed that.
No, we have not agreed.
Oh,
No, we have not agreed.
I will continue. My apologies. Further, Your Honor, the only person with the authority to revoke the Hassan certificate of naturalization in an event that the citizenship is contested is according to Section 10 of the Commonwealth of Dominica Citizenship.
But sorry, let me help you here again. Let me help you now.
Yes,
You were going to move on from citizenship on the basis that we have all agreed.
yes.
I think you can move on the basis that you will leave the court to see it in your written submissions. So you will move on because you rely on your written submissions and you will not make any further advocacy on citizenship. Yeah?
Thank you, Your Honor. I
Very
have.
All right.
Given the established fact that the Hassans, given the fact that we will refer to our written submission that the Hassans possess valid Dominican citizenship, thereby rendering TT distributors eligible as nationals of a member state, we may now examine Trinbago's infringements upon the rights granted to TT distributors under the RTC. The right of establishment emphasizes the non-discriminatory right from Article 7 of the RTC. This court, in TCL against Guyana, paragraphs 26, referenced the preamble of the RTC and held that the rights under Chapter 3 of the RTC, including the right of establishment, are fundamental core rights that must be seen in the context of the resolve of the contracting parties to establish conditions which would facilitate access by their nationals to the collective resources of the region on a non-discriminatory basis. Because the right of establishment emphasizes the non-discriminatory right from Article 7 of the RTC, Trinbago's refusal to honor the 40% CET discriminates against TT distributors by creating a financial burden and violating their right of establishment under Article 32(3)(1)(b).
I'm struggling to understand the infringement of the right of establishment. Was the company established in Trinidad?
Yes, Your Honor, the company was incorporated into Trinidad.
Is it allowed to conduct its business in Trinidad?
Your Honor, it is allowed to conduct its business in Trinidad, but the benefits it should be receiving as a business incorporated under the Treaty of Chaguaramas, it is not being able to receive.
What is that benefit that it is not receiving?
Those benefits are certain rights, including the waiver of CETs for the circulation or importation of community origin goods. And in this case,
No, wait. They have a company incorporated in Trinidad. They are established in Trinidad. There's been no hindrance to establishing themselves in Trinidad or conducting their affairs in Trinidad, i.e. producing and selling. Agreed?
yes, Your Honor.
Okay. So the infringement of the right to establishment is in relation to the benefits that they should be deriving, having been established.
Yes, Your Honor, because businesses within the community, private entities within the community are supposed to be afforded certain benefits
Yes.
when they are being established.
So what exactly is the detriment? So they've been established.
Yes.
They can conduct their business. They are conducting their business. Yeah?
Yes, Your
So what is the disadvantage or the detriment?
The detriment is this financial burden that is being placed on TT distributors because as a result of the lowering of the CET on third-party soap noodles, Trinbago Soaps Limited would only have to be paying about 5% on their tax, and being able to import soap noodles from other third-party states at such a lower cost will ultimately affect the market of TT distributors. Well, it will ultimately affect their market as they will be able, Trinbago Soaps Limited, that is, to sell soaps and soap products for a much cheaper cost than those importing community origin goods would be able to do.
Okay,
Yeah,
so
I think we follow what you're saying, Ms. Bash. I see that you've relied on Article 7, the non-discrimination. Is that something that you have put in your special leave application?
Your Honor, I will not be able to answer that at this time
Oh,
because I don't think we have.
you know, that's what I think. When you don't think you have, you say to the court very directly, no, we have not,
But we have
unfortunately.
not, Your Honor,
Yes.
unfortunately.
I understand. But I am intrigued by it because I wondered if you could let us know then how you see Article 7 tying in with what you say is a breach of the right of establishment.
Your Honor, in my personal opinion, when I look at the revised Treaty of Chaguaramas, the concept of non-discrimination is evident throughout the entire treaty. It is there in the preamble, it is specifically there in Article 7, but it is emphasized throughout the entire treaty, and this court has also agreed that it is emphasized in other articles as it said so in TCL against Guyana, specifically in the judgment of that.
So you think that even though you did not mention it as a specific breach of Article 7, because it's not what we call standalone, that you think that the court can still take it into
Yes,
account?
Your Honor. I think that Article 7 and the concept of non-discrimination is just flowing without the treaty, flowing
Yes.
throughout the treaty,
You would use the word permeates then.
permeates throughout the treaty.
Thank
Yes,
you,
Your
Ms.
Honor.
Bash. Yes.
Permit me to continue my
Yes,
submission?
please.
Yes.
Yes, please.
So the court in paragraph 42 of TCL against Guyana reiterated the fact that private entities could suffer a severe disadvantage if the non-discriminatory principles under Article 7 are not adhered to. In the case before this court today, this severe disadvantage, as I would have mentioned earlier, being faced by TT distributors as a result of Trinbago's refusal to honor the 40% CET, is the financial burden that exists as a result of allowing Trinbago soap to import soap noodles at a lower cost. Not only is allowing them to import third-party soap noodles with a lower CET contrary to the court's decision in TCL against Guyana paragraph 26, and contrary to the preamble of the RTC, which aims to promote the objectives of the CSME, and one of those very important objectives is that of economic leverage. But they are also depriving TT distributors of the benefits afforded to them as nationals of a member state. By ignoring and allowing Trinbago Soaps Limited to import third-party soap for a significantly cheaper price, the defendants are creating a situation whereby TT distributors are at a competitive disadvantage. They will not be able to compete with the prices of Trinbago Soaps Limited and will essentially be run out of business.
Are you still on your right of establishment point, ma'am? Okay, thank you.
By ignoring and allowing Trinbago Soaps Limited to import third-party soaps for a significantly cheaper price, this is what occurs. This court in SM Jalil paragraph 44 held that community law as enshrined in the treaty and developed by the court should not only aim to prevent and repair individual loss and injustice, but also to preserve and protect the economic welfare and prosperity of the community as a whole. As stated by Mr. Vikesh, the manager of TT Distributors in the facts, This refusal to honor the CET will bankrupt TT distributors by depriving it of its main market, and this does not protect the economic welfare and prosperity of the community as a whole.
Ms.
Your Honor,
Bax,
yes,
excuse me here.
yes, Your Honor.
Premising that the state was wrong to, through the controller, wrong to use a 5% tariff. That violates the provision in the treaty, the CET of 40%, etc. But is that failure to implement that tariff, the correct tariff as you are arguing it should be, is that a breach of the treaty which should be taken up before this court, or is this a domestic matter?
Your Honor, this is a matter that should be taken up by this court. I will not be delving into this specific issue, but in my junior counsel's submission, she will be making reference to Articles 1A to 4 and 1A to 5 specifically of the RTC that deals with member states' duties rather, to protect the rights of certain consumers, and those rights are not being protected in this instance. I can elaborate a bit more if.
Okay, but I think I will wait with bated breath to hear your junior counsel on that. Continue.
Elaborating or?
Your choice.
Okay, Your Honor. Your Honors, it is also submitted that the Republic of Trinbago has frustrated the benefits afforded to TT distributors' products as community origin goods, and thus breached Articles 82 to 84 of the RTC. Article 82 of the RTC mandates member states to apply a CET on goods ineligible for community treatment, and this includes soap noodles when looking at Schedule 3, paragraph 18 to 19. Further, Your Honors, this court in paragraph 25 of TCL against the Caribbean Court emphasized its previous decision that the establishment and maintenance of the CET on goods is of potential benefit for private entities within the community. TT Distributors is one such entity, and Trinbago's attempted suspension of the CET on soap noodles and its inaction towards the misclassification suggests a violation of the good faith principles overarching the RTC, as this court in paragraph 43 of SM Jalil held that member states must perform their treaty obligations in good faith. The defendant Trinbago has breached Article 82 and paragraph 18 of Schedule 3 of the RTC, and the nature of their breach is one that is a violation of the good faith principles overarching the RTC. As it relates to Article 82 specifically, the case in point here is DCP successor.
So just a minute, Ms. Bash. Okay, you're speaking about the overarching good faith principle.
Yes, Your Honor.
But is there unlawfulness or illegality in what have they done? How have they? This is a classification or a misclassification,
Yes, Your Honor.
right?
Yes.
Okay, so you say that is a good faith, that is in contrary to the principle of good faith. Yeah, but is that expressly in breach of the provisions of the RTC?
Your Honor, it is not an express breach, but since they are acting without good faith, they're acting in bad faith in this situation.
But why do you say, is it not correct that on soap noodles, the CET is 40%?
Yes, Your Honor.
And
it is,
you are submitting that these are soap noodles?
yes, Your Honor.
There is a basis for changing the 40%?
No, Your Honor.
No, you can apply to change the 40%, can you?
Yes, you
And
can.
if you don't, you shall apply the 40%,
Yes, Your Honor.
right?
And the only person that can change that is Kote.
Right? And was it changed?
No, Your Honor.
Right? So is this just?
No, Your Honor.
Good
it is
faith?
unjust. It is illegal. It is a breach of the treaty rights.
Is that where the good faith comes in? That the state of Trinbago
Yes.
says, we may have misclassified it. Let us say that is what they say, but we did it in good faith.
No, Your Honor, the bad faith comes in where Trinbago seems to have knowledge that this misclassification has been done. They seem to be aware that it was indeed misclassified, as they were the ones who applied for the safeguard certificate. They were the ones who applied for a suspension of the 40% CET, and they were also made aware through Mr. Vacacious letters. They were made aware through various
But,
publications.
but that's the point. The factual matrix is when your client at customs first heard about these goods coming in, there was an oral complaint. In fact, I think your client was taken out physically.
Yes, Your Honor.
Then subsequent to that, I recall the factual matrix is they wrote several letters to prime minister and ministers, etc. So I think what the president is asking is whether or not the good faith principle comes in because what the state did when it was brought to their attention suggests that they could not have had good faith when they said that it was just a innocent misclassification.
Yes, Your Honor. You've explained it better than I did.
Well, yeah.
Kind of thing.
Yeah. Miss Bash, I don't know how much longer you have. I'm not sure about your time, but we have taken up a little bit of your time.
Oh.
So we would give you a couple minutes if you wish to wrap up. Is that the time left? Half a minute? Yes, okay, to finalize your points.
Yes, Your
Yes.
Honor.
Mhm.
So permission to have extra time?
Yes, 2 minutes, because
Thank
we've taken up a bit of your time.
So in the case of DCP successors against Jamaica, this court considered whether Article 2 of the RTC was breached. And in that case, the court found that in the absence of a suspension from COTED, Jamaica was in breach of Articles 82 and paragraph 18 of Schedule 3 of the RTC. And this is a very similar case in this instance, the one before us today. So similarly, the defendant Trinbago has breached Article 82 and paragraph 18 of Schedule 3 of the RTC. And the nature of their breach is one that violates the good faith principles overarching the RTC. And that was mentioned and referred
But sorry,
to in the
but why
Jaleel.
do you keep coming back to this good faith? They are in breach of the article. You don't need good faith after that.
Yes, Your Honor.
Yeah.
Yes. The defendant in this case did not have any such good faith, but they are in breach of the article. So further, Your Honors, the Comptroller of Customs has a duty to act in good faith as well to enforce community rights, including those outlined in Articles 82 to 84. Article 17.4 of the Charter of Civil Society states that in order to ensure morality in public affairs, the holders of public office should not act in a matter that is against the public interest. By not enforcing the CET, the comptroller on Trinbago's behalf has frustrated the benefits entitled to community members, creating a competitive disadvantage for TT distributors and acting against the public interest. It is our submission that it was the defendant's objective to frustrate the benefits entitled to community goods, contrary to the aim of the CSME and contrary to the preamble of the RTC, and they have breached Articles 32, Articles 82, and Articles 84 of the RTC. Your Honors, unless there are any other questions, this is the extent of my submission.
Anything? Just
But I just want to clarify one thing at the end. Is it then your submission that the breach of the effects of the breach of Articles 82 to 84, those effects are what undermine the right of establishment? These two, they are not separate in that it is because of the misclassification and the removal of the 40% CET that you are arguing that the effects of that have undermined the right of establishment. Is that what you are saying?
Your Honor, I did not say that explicitly.
No,
but
I'm asking if that,
Yes,
not
that
whether
is-
you said it,
Yes, that
I'm
is what
sorry.
I'm saying.
Is that what your submission
Yes.
amounts to?
Yes, Your Honor. My submission amounts to the fact that, well, our position is that because of these benefits, because of certain rights, these specific actions and inactions by Trinbago have amounted to these breaches.
Thank you.
Thank you, Your Honor.
Thank you very much, Ms. Bash.
Thank you.
Yes. And your junior counsel will come? Yes. Thank you, ma'am. Ms. Duki, is it? Yes. Thank you, Ms. Duki. Please proceed.
May it please this honorable court. We submit that Trinbago's inaction towards a safe and clean campus constitutes a breach under Article 91.1 of the revised Treaty of Chaguaras, hereinafter referred to as the RTC. We submit, firstly, considering the absence of regional legal precedent relating to the application and interpretation of Article 91 of the RTC, report shall be made to ECJ case law. Secondly, a domestic product promotion campaign constitutes a measure with an equivalent effective quantitative restriction contrary to Article 91.1 in conjunction with Article 91.4 of RTC. And thirdly, we submit that Trinbago incurred liability under Article 91 due to its inaction to implement measures to intervene in TPSO Safe and Clean campaign, which frustrated the free movement of community origin goods, particularly laundry soaps. The first issue I'll delve into is whether a domestic product promotion campaign constitutes a measure having an equivalent effect to quantitative restrictions. Under Article 30 of the EEC Treaty, referenced in paragraph 28 of the Commission of European Communities against the French Republic, hereinafter referred to as the Commission against France, quantitative restrictions on imports extends to measures having an equivalent effect. We submit that TPSO Safe and Clean campaign on behalf of Trinbago soaps falls within Article 30 and should be considered as a measure with equivalent effect to quantitative restriction under Article 91.1 and Article 91.4 of the RTC, given that these articles mirrors that of the Article 30 of the EEC Treaty.
Can you explain that to us, Ms. Duki? How, in fact, does that fall to be a breach of Article 91?
Sure,
I'm
Your
interested
Honor.
in that submission.
So pursuant to paragraph 20 of the Commission of the European Communities against Ireland case, the ECJ upheld that a Buy Irish campaign and the measures taken to prosecute that campaign, which included the organization of a big publicity campaign by the Irish Goods Council in favor of Irish products. This also involved publication and distributions of literature encouraging consumers to buy domestic products only. The court held that it
Sorry,
was
counsel. In that case, there was a discrimination in favor of a domestic product against an imported product.
Pardon, Your Honor?
A domestic product in
Yes.
favor of a domestic product as
Yes, Your Honor.
and discriminating against an imported product.
Yes, Your Honor.
Where is the parallel here? The two soaps are made in the one jurisdiction.
Pardon, Your Honor.
Two soaps are made in the one jurisdiction. So there is not any discrimination against the imported product, is there?
Yes, Your Honor.
Which is the imported product?
The imported product is the bluest laundry soap. That the imported product is the bluest laundry soap that was imported from Indonesia. So the imported product is the bluest laundry soap that was imported from the soap noodles from Indonesia. So what happened here is that the campaign, the TPSO campaign, and Trinbago soaps, they imported these soap noodles from Indonesia. However, they were simply a packaging company, as the facts clarified. So they simply labeled these soaps as made in Trinbago. In actuality, these were soaps imported from, soap noodles imported from Indonesia.
And the campaign was in favor of this Trinbago soap, right? In favor of.
Yes, the campaign
And,
was
and it was discriminating against
domestic product.
against TT distributor soap, right?
not only TT distributor soaps, but other community origin goods as well, because they had the underlying intention to promote their product under the disguise of promoting domestic products.
Yeah, but the discrimination, that's what I am concerned about. There is not, Article 91 speaks about restrictions on exports and restrictions on imports. I'm trying to get in my head, and I depend on you to help me, what is the restriction on imports or exports involved in this scenario where there's a campaign locally by an organization in favor of one soap manufactured here in Trinbago against another soap manufactured here in Trinbago? You see my difficulty? If I'm not making myself clear, tell me.
Can you simplify it some more?
Yes, as simple as this. The TPSO has launched a campaign to support Bluest Laundry soap. That is a soap made in Trinbago.
I object, Your Honor. It's
No.
not a soap made in Trinbago.
Where was it made?
It was made primarily from materials
You're
imported.
telling me about the source of the raw goods.
Ms. Dookie, if I can just try and, can you do the factual matrix? Do you have the facts before you? Look at paragraph 3 of the facts.
One moment.
This is a question of fact, is it not? So you need to know the facts at your fingertips. All right, have you found it?
Yes, Your Honor.
All right.
So the primary business of TT distributors is to import soaps from Dominica,
Soap products.
soap products from Dominica into Trinbago, including soap noodles, which can be shipped into products including laundry bar soaps and bath bar soaps. TT distributor ships the noodles and packages them as 3 products: TT blue laundry soap,
Yes.
TT bar soaps, and TT facial cleanser.
And the last sentence.
All 3 products are labeled as having been packed in Trinbago.
So let's go slowly. The label has been packed in Trinbago. Go on.
And that they are of Dominican origin and only use natural ingredients.
Right. So those are the facts. And the campaign says what?
And the campaign that's for Trinbago soaps is saying that TT, that their soap is made in Trinbago. However, we can make a comparison between the two because TT distributors, they imported soap noodles from a community national. And when they imported soap noodles from a community national, they labeled it as it was made in Dominica, but it was packaged within Trinbago. Likewise, Trinbago soap should have labeled their stuff as made or manufactured in Indonesia, as opposed to made in Trinbago, because it was simply packaged in Trinbago. They are a packaging company, as our facts tells us.
Yeah. Ms. Uki, I understand what you're saying. And I'm interested in this though. How does what you have said to us, how does this become or amount to a measure equivalent to quantitative restriction?
Surely, Your Honor. In the case of Apple and Pear Development Council against Lutz, the ECJ distinguished campaigns that, on the one hand, discourage the purchase of products of other states, disparage those products in the eyes of consumers, or discriminate on grounds of natural origin, and on the other hand, those that promote the specific qualities or properties of a national product. The former breaches the prohibition of measures equivalent to quantitative restriction, while the latter does not. We submit that the Safe and Clean campaigns purposefully misled the public regarding the origin of Trinbago soap's Bluest laundry soap with an intent to discriminate against community origin goods. Trinbago Soaps is a soap packaging company imported soap noodles from a third-party state and shipped them into Trinbago Blue West laundry.
All right, so one is the misleading with respect to origin. Yeah. What else? What the president is asking is, we understand what the Ireland case says. Tell us on the facts of this case. One is that they have misrepresented, you say, the place of origin. All right, what else?
So, under the guise of encouraging consumers to purchase Trinbagonian products, so they knew that their soap was not of Trinbagonian origin. It was of Indonesian origin. Yet they were having this big campaign to promote their soap under the guise of supporting Trinbagonian products. They even made the declaration that other soaps were on sale, that other soaps did not use natural ingredients, when in actuality, TT distributor soaps included.
So that's a second misrepresentation, an allegation that your client's soaps were unsafe because they did not use natural products when that was untrue.
Yes, Your Honor.
Mm-hmm. And how would that affect or impact your market? It is an allegation of unsafety, right?
Yes, Your Honor.
On a false premise. But how would that impact your client?
This would disparage our products in the eyes of consumers, thereby putting us at a disadvantage. This campaign reached the prohibition of measures with equivalent effect to quantitative restriction, contrary to Article 911 of the RTC, because as considered before in Apple and Peer Development Council, where the ECJ says that where the campaign discourages the purchase of products of other states or disparage those products in the eyes of consumers, it breaches the prohibition of measures equivalent to quantitative restriction.
I follow you, Ms. Duque. A few things. One, I know your time is going, but there were things that your senior counsel promised us that we would hear from you, and I have not forgotten that. The other thing is that the other side has raised and has said that this is a matter of competition law, as I see it, within the domestic courts or within the national sphere. What do you all say of that? What does TT Distributors say of that?
Your Honor, taken from a presentation by Mr. Justice Ralston Nelson in July 2005, he noted what the West Indian Commission said about the vision of the Caribbean Court of Justice. And under this, he noted that our recommendation is that the court should have an original jurisdiction in matters arising under the revised Treaty of Chaguaramas, and that any CARICOM citizen, be it an individual or a corporate, and every government of a member state of the community or the CARICOM Commission itself should have the competence to apply for a ruling of the court in a matter arising under the treaty. And under Article 222 of the revised Treaty of Chaguaramas, it makes provision for private entities to bring a claim before the Caribbean Court of Justice, whether it's in relation to a matter of natural justice or whether it's in relation to...
Are there conditions to be satisfied? You are coming under Article 222 for special leave. You've come to this court this morning seeking special leave, right?
Yes, sir.
And you are coming under Article 222, is that correct?
Yes, sir.
All right. Do you have to satisfy anything to succeed? Are there conditions in Article 222 that must be met to succeed?
Your Honor, so a breach must have been done to our rights conferred under the revised Treaty of Chaguaramas.
Yes.
And as my senior counsel would have mentioned, we have been deprived of our rights.
So you satisfy that first condition. Any other conditions?
It is a duty pursuant to Article 791 of member states to maintain and establish a regime for the free movement of goods within the Caribbean single market and economy. However, Trinbago has failed to oblige to this duty, and I think that the court should find interest of justice that requires TT distributors to be allowed to espouse this way.
So you say that is the last of the many conditions or factors under 222, interests of justice. And you say you satisfy these?
Yes, Your Honor.
Okay. I think you're running out of time. You want to wrap your points up?
Yes, Your Honor. May I be permitted?
Just a few seconds, please.
Under paragraph 35 of the Commission of the European Communities against France, it fell on the court to verify, in cases before it, whether the member state concerned has adopted appropriate measures for ensuring the free movement of goods. Likewise, considering Article 222, in conjunction with Article 31E and 31N of the RTC, both Dominica and Trinbago are signatories of this treaty and have an obligation to uphold the provisions under the RTC. However, Trinbago has failed this obligation, breaching Article 9.1 of the RTC, and therefore original jurisdiction lies with this court to adjudicate on the inactions of the defendant. We therefore seek a declaration that the defendant's inaction towards a safe and clean camping constitutes a breach under Article 91.1 and an order requiring Trinbago to impose the 40% common external tariff applicable to soap noodles. Thank you.
Thank you.
Thank you very much, Ms. Dukey. Ms. Bash, I take it that is your first salvo, as you do have a reply? Yes, thank you. Yes, and the TT distributors on the other side, sorry, Trinbago, the state of Trinbago. Is it Mr. Derby or Mr. Darby?
Derby.
Huh?
Derby.
Derby, thank you. Yes, you may begin.
Good morning, Your Honors. May it please the court. My name is Leroy Derby, and I am the senior counsel representing the Republic of Trinbago, the defendant in this case before this court. I am joined by Ms. Edith Lindfeld, who is the junior counsel, and Ms. Freen Boomhard, our researcher of the team, who shall be assisting as needed. I will be arguing as the senior counsel that the Republic of Trinbago has not violated the Articles 32 and 82 till 84 of the revised Treaty of Chaguaramas. The junior counsel shall argue that the Republic of Trinbago has not violated Article 91 of the revised Treaty of Chaguaramas. With special leave of this court, I would like to start with my first argument. Your Honors, this court has no jurisdiction as TT distributors is not entitled in the rights of establishment of which is entitled within the community, because these rights are only available to community nationals according to Article 32, Paragraph 5, Sub C, Point 2 of the RTC. The company Dominican Soaps, which effectively controls TT distributors, is owned by the Hassans for 100%. They, however, should not be regarded as community national as it poses safety concerns for our community.
Sorry, which article is that?
Article 32, Paragraph 5, Sub C, Point 2.
It's about a safety concern?
Yes, Your Honor. Syrians, can I?
Just hold, just well.
Yeah, go ahead.
Okay, thank you.
Go ahead, please.
Thank you, Your Honor. The Syrians, known as the Hassans, are ineligible for the citizenship they obtained in 2021 under the Citizenship by Investment Program of the Commonwealth of Dominica. The Hassans, Your Honors, do not meet all requirements set out in the Citizenship by Investment Program, in particular, Article 5 Sub B of the Commonwealth of Dominica Citizenship by Investment in 2014, SRO 37, which states that an applicant who has a criminal record other in respect than of a minor offense shall not be approved a citizenship. Your Honors, the Hassans were convicted of fraud and sentenced to 5 years imprisonment
What?
in
I'm sorry. What was the thing you just read? That is the
Dominican Citizenship Act.
specifically provides at what section?
Article 5 sub D,
And that says that if you're convicted of a criminal offense,
other than in respect of a minor offense, shall not be approved the citizenship.
right? Okay, thank you.
Sorry, so that is a domestic law in Dominica.
Yes, Your Honor.
And you are saying that this court should enforce that law?
Your Honor, they don't have jurisdiction as they do not get the rights of establishment according to Article 32.
You are saying the state of Dominica gave them citizenship,
Yes, Your Honor.
right? And you are saying that this court should decide that the state of Dominica was wrong because of this provision to have given them citizenship.
Yes, Your Honor.
So you're asking this court to pronounce upon the validity of a local law and as well upon the, as it were, implementation, enforcement, or non-enforcement of a local law, correct?
Your Honor.
Mr. Derby, you've not told us anything about the test for nationality in international law. Are you going to go there today?
Oh, yes, Your Honor.
You are?
Yes, Your
Okay, you want to tell us about that now? The test of nationality in international law. Are you saying that that has not been met as well? I'm not sure what your case is.
Your Honors, the Hassans are convicted of fraud, and it's not only a domestic matter, it's only a matter for our community because it's poses safety concerns.
I follow you, but you go ahead. I have something else to ask, but I'd like to hear you a little more on Article 32. So proceed, please.
Proceed?
Yes, please.
Okay, thank you. As mentioned, Your Honors, they were convicted of fraud and sentenced to 5-year imprisonment in Syria in 2021 and immediately fled to the Commonwealth of Dominica. Till this day, their names still remain on the Interpol list as convicted criminals, which is a violation of Article 226, Paragraph 1, Sub A of the RTC. Your Honors, it was an obligation of the Authority of Dominica to do background checks and due diligence on the integrity of the applicants as stated in this Commonwealth of Dominica Citizenship by Investment 2014 as Row 37. Subsection 4, paragraph 11 is a focus point on this part. Checks on criminal records are included in the Citizenship by Investment program.
Mr. Derby, forgive me, and I'm sure we will give you a bit of extra time for this, but you have been greatly puzzled by this reliance upon the local legislation and the assertion that the Hassans have this criminal conviction, etc., and your assertion that what the state of Dominica did was in fact a nullity or was invalid or something. So that would require us, this court, to make a determination of all of these questions, wouldn't it?
Simplify it for us, Your Honor.
Sorry, are you understanding me?
No, Your Honor, it's a local legislation that affects the community.
Yeah, but the question is, you're saying that under the local legislation, these people have a criminal conviction.
Yes, Your
Yeah?
Honor. And they are on the Interpol list.
Right. Do we know what the state of Dominica did before giving them citizenship by investment? Do we know if the state inquired into that conviction? Do we know if the state decided that that was a human rights violation? We will not regard that conviction in that foreign state as a valid one, etc., etc.
Your Honor, if someone is on the Interpol red list as convicted criminals, then it's very easy to do proper background checks.
Yeah, but we don't know if they did.
They gave these Hassans.
We
this.
don't know if they did and decided that notwithstanding that they are on the Interpol list, we, the state of Dominica, have conducted our own inquiries and we are satisfied that this was in fact a wrongful conviction made by a court in a corrupt country, etc. I'm not saying that the country is corrupt, you know. I'm saying that it is a competent determination for the authority in one state to see how they will treat the actions that have taken place in another state. So we do not know what went into this determination made to give them citizenship. So what you are saying is Dominica ought not to have done so. And that would involve our deciding whether Dominica ought not to have done so. You see our difficulty?
No, Your Honor.
You don't?
No, Your Honor.
All right. Our difficulty is that we would, in such a case, for instance, be required to say, hold on, before these proceedings go any further, you, the complainant, who say that these people do not have proper citizenship, you need to go to Dominica and make an application to have this citizenship revoked. You need to go before the courts of Dominica and say to the court that there was a wrongful application of this citizenship by investment law. It is corrupt, it was fraudulent, it was obtained in wrong circumstances, and we, the complainants, are asking the court to strike out this citizenship by investment status. You see what I'm saying?
Your Honor.
Yeah.
We,
Like I said, we have gone into your time,
Yeah.
but I'm just saying what is involved in this matter of national law. Yeah?
Yeah, we follow what you're saying, Mr. Derby. So I think you want to tell us some more things about the right of establishment, and then you want to go on to your 82 to 84 point? Yes, please. Please proceed.
Yes, Your Honor. As mentioned, the Commonwealth of Dominica actually failed to do proper due diligence on the Hassans.
Okay, so you can move on from that, please, and go to your right of establishment point if you have those to make, and then proceed into 82 to 84.
Okay, thank you.
Thank you.
So can I conclude the first part?
Sorry?
So should I conclude the first part?
Yes, please.
Okay, Your Honors, my conclusion of the first submission is very important for country to do their proper due diligence and to prevent or mitigate risk of money laundering, fraud, and corruption within the community. Furthermore, Your Honors, according to the Trinidad Cement Limited and TCL Guyana versus Guyana 2019 CCJ OJ, paragraph 26, the core rights of the rights of establishment are only available to community nationals and are not available to non-community nationals merely doing business in the community or companies which, though incorporated in a contracting party, are not substantially owned or effectively controlled by community nationals. These rights, Your Honors, are intended to ensure strategic economic advances remaining with the persons belonging to or having a close connection within the community. Therefore, Your Honors, Article 32 of the Revised Treaty of Chaguaramas was not violated, as TT distributors is not entitled to have the rights of establishment within the community.
Yeah, Mr. Derby, you were here when my brother Justice Jamada asked the other side, TT Distributors Council, a question about 32. How does 32, in your view, endure for the benefit of TT Distributors if they are a company established in Trinbago?
Your Honors, in this specific situation, TT Distributors is effectively controlled by Dominican Soaps, which is 100% owned by the Hassans. And this is the link between Article 32, paragraph 5, sub C of the Part 2 of the Revised Treaty of Chaguaramas.
Yeah, I follow you completely. You may pass on to your 82 to 84 point because I think you're running out of time.
Thank you, Your Honor. I would like to continue with my second part for my second argument. And we, as the Republic of we as councils of the Republic of Tobago can ensure that the member state never intended to frustrate the benefits of community origin goods received. We can assure the court that we have always maintained a common external tariff of all goods which do not qualify as community origin goods. Furthermore, we as CARICOM member states should always support each other in the hope for a better
Right, so
future
yeah,
for our
so
community.
yes, those are nice statements to make.
They are what a good politician would state.
Yeah, but in a court of law, the facts, do you accept as a matter of fact that you misclassified what you were importing?
It's not misclassified, Your Honor. It's a mistake of the council controller.
All right, so would you agree that your mistake resulted in a misclassification?
No, Your Honor, it's just a mistake of the customs controller.
Yes,
A mistake in applying the wrong classification.
Yes, Your Honor.
yeah, okay, good. So we're moving along. So if it was a mistake in classification, then you agree that the right classification would attract 40% CET.
Yes, Your Honor.
Good. You say, however, don't hold that against you because you acted in good faith, correct?
Yes, Your Honor.
Right. So speak to us in the time you have limited, because that's where this part of your argument lies. For you to persuade us that you acted in good faith, because if you did not act in good faith, then there could be some consequences. Agreed? Yeah. So tell us why should we accept that you acted in good faith?
Because, Your Honor, the manager of TT Distributors, we applied for a safeguard certificate, Your Honors, according to Article 84, Paragraph 3 of the RTC, because it's an inadequate supply of soap noodles within the region. And furthermore, the Republic of Tobago followed every rule according to Paragraph 19, Schedule 3 of the RTC. And in order to obtain the safeguard certificate, Paragraph 19, Schedule 3 of the revised Treaty of Chaguaramas also states that the Secretary General shall take in consideration the allocation and provision laid down in Schedule 3.
Mr. Derby, what is the purpose of a safeguard certificate?
Your Honor, you can apply for a safeguard certificate if there is an inadequate supply of community of goods which are not available in the community.
And what does that allow you to do if you should obtain a safeguard certificate?
Can you repeat the question?
What should that allow the state of Trinbago to do if you had received the safeguard certificate?
Your Honor, if it's an inadequate supply, then we should always, you should also follow every rule according of the procedure, which is mentioned in the RTC, and then you can import products and maintaining a CET.
Is that the purpose of the safeguard certificate?
That's one of the.
Yeah, I want to hear you on it when you come back to the podium, Mr. Derby. So no, you will not be coming back, but I'd like to know, have you looked at this point at all?
Yes, Your Honor.
Okay, you may pass on.
Okay. Thank you, Your Honor. In the DCP Successes Limited versus the State of Jamaica in 2024, CCJ 10J, in paragraph 135, it is mentioned that according to Article 84, paragraph 5 of the RTC, the Secretary General has the obligation to conduct inquiries of the competent authorities in other member states to determine their ability to supply a regional material required by the manufacturers. Furthermore, Your Honor, while the manager of TT Distributors wrote letters to the Prime Minister, the Attorney General, and Minister of Finance, they did not give the Republic of Tobago adequate time to investigate the issue, as this case was brought to the court. Also, Your Honor, on the contrary, the TT Distributors manager purposely leaked letters to prominent media before the government of Trinbago even get the chance to conduct proper investigation, and this can be qualified, Your Honors, as violation of good faith. We acknowledge that the comptroller made a mistake on the CET for the soap noodles. However, the Republic of Trinbago did not get the opportunity to correct this mistake as this case was brought to court. The Republic of Trinbago, Your Honor, still awaits the results of the investigation to take proper actions.
Counsel, did it subsequently correct the mistake?
Your Honor,
Did the state subsequently correct the mistake?
that's why there is an investigation, Your Honor.
Huh?
That's why there is an investigation to get enough evidence what really happened.
No, that is what took place up to the time when the case was brought. I'm asking now, this is what the court would do in a live case. Has the state subsequently, after the facts of this case, has the state subsequently corrected the mistake? Is the controller of customs now applying a 40%? Or is the controller of customs now still waiting to be told that the safeguard certificate, the refusal stands? You see what I'm asking? You're claiming lack of time.
Sorry?
You are claiming lack of time.
Yes.
Yeah. And I'm saying, all right, so time has passed. No. What's your position?
Position at this moment, Your Honors, is that the lead letters acted in bad faith, but we are able as counsel to remind the Republic of Trinbago to correct this mistake as we can.
Okay. Continue.
So that your position is to advise the Republic of Trinbago to revert to 40% until you can have a proper investigation. And that's what you're saying to this court as counsel.
Yes, sir.
And we commend you on that approach before this court, yeah.
Can I continue?
And,
Yes,
and we know we put you under some pressure,
Yeah.
but thank you for that.
Yes, Your Honor.
And may I say that was very well done on your part.
Thank you.
Continue.
Your Honor, this mistake of the Comstar controller occurred once, while in other cases it happened repeatedly where member states purposely, repeatedly misclassified the goods. If we take a look at the Hummingbird Rice Mill Limited versus Suriname in 2012, CCJ 10J 2012, which is referred in the SM Jalil & Co. Limited and Guyana Beverages Incorporation and the Cooperative Republic of Guyana, the member state purposely kept using the wrong tariff heading. Based on the Customs Controller Act of the Republic of Trinbago in Article 213, the Republic of Trinbago shows that the investigation shows that the comptroller has violated the Customs Act and he will be penalized for such acts.
Can you wrap up first then, Mr. Derby?
Okay?
You're out of time.
Yes, you're out of time. So if you can wrap up, please.
Yes, I'm at my conclusion in a moment.
Yes,
Thank you,
thank
Honors.
you so much.
In conclusion, the Republic of Trinbago never intended to frustrate the benefits of TT distributors' products received as community origin goods. Therefore, Article 82 till 84 of the revised Treaty of Chaguaramas were not violated. We ask this honorable court, Your Honor, that the defendant did not breach the Articles 32 and Article 82 till 84 of the RTC. We also request the court to give the Republic of Trinbago the opportunity to complete their investigation on the mistake of the comptroller, as the Republic of Trinbago is committed to maintaining the correct CET. Thank you, Your Honor.
That's it. Thank you so much, Mr. Derby. Your junior counsel can come now. Ma'am, we do not have Justice Witt to guide us with the correct pronunciation of your name. So please help us. How do you want? What is it?
Edith Lindfeld.
Lindveld?
Yeah.
Good, okay. You will excuse any lack of proper pronunciation.
Edith.
Thank you. Please proceed, ma'am.
Good morning, Your Honors. May it please the court,
as announced by the senior counsel, I am the
If I
junior
may
counsel.
interrupt, you are very fluent in English, aren't you? Do continue, yes?
I am the junior counsel, Edith Lindfeld, representing the Republic of Trimbago, the defendant in this case before this court. I will be arguing that the Republic of Trimbago has not violated Article 91 of the revised Treaty of Chagaramas. The Republic of Trimbago argues that this court does not have jurisdiction in this matter based on the following arguments as stated in our skeleton. Firstly, the Republic of Trimbago is not liable for the actions of the TPSO, Trimbago's private sector organization, as it is an NGO established under private law, receiving no funding or not being managed by the government of Trimbago. Secondly, the Republic of Trimbago had no obligation to adopt adequate measures to deal with the actions of the TPSO because the Safe and Clean campaign run by the TPSO did not frustrate the free movement of goods. Given that these are purely private measures that do not frustrate the free movement of goods, this matter falls under competition law, which falls under the natural jurisdiction of the Republic of Trimbago. Your Honors,
That it falls in the realm of competition law, and that is for the local court. That is for the courts in Trinbago. Yeah. Thank you.
Your Honors, due to the lack of relevant case law in the region, I will be referring to case law of the European Court of Justice to interpret Article 91, Paragraph 1, and Article 91, Paragraph 4 of the revised Treaty of Chagaramas to support these arguments. Your Honors, as stated in Article 91, Paragraph 1 of the revised Treaty of Chagaramas, a member state shall not apply any quantitative restrictions on the importations of goods which are of community origin. We see that TPSO's actions cannot be equated with the actions of a member state as they are purely private. We see in the European cases, Commission versus Ireland, 1982, paragraph 6, and the Commission versus Germany, 2002, paragraph 18 to 21, that the member state was held liable when the state either funded or managed such an entity. However, Your Honors, we also see that the TPSO is a privately owned NGO established under private law, receiving no funding from the Republic of Trimbago.
Just a minute. Are you saying that these two cases establish a principle that if it is an entirely private organization or individual who is not funded by the state cannot be liable?
The state is only liable, as for my second argument. So the two criteria that it needs to meet is that it's either if it's a private action done by a
If it
private-
is a private action, are you saying a state can never be liable?
It can be liable.
Can be liable.
Yes. If
All
those
right.
actions frustrate the free movement of goods.
Okay.
And your second point, you said?
That is
You-
my second point. Additionally, Your Honors, TPSO operates independently of the Republic of Trimbago, with their members not appointed or supervised by public authorities. Your Honors, as for my second argument, based on the European case, the Commission versus France, 1997, paragraph 28 to 32, we can interpret that Article 91, in conjunction with Article 79 of the revised Treaty of Chagaramas, also applies where a member state abstains from adopting adequate measures required in order to deal with obstacles to the free movement of goods. Your Honors, if you look at the Safe and Clean campaign, it did not frustrate the free movement of goods. We take a look at the case Apple and Pear Development Council versus KJ Lewis, 1983, paragraph 18 to 21. A campaign is allowed to promote the sale of certain varieties of a product. Namely, we see the use of blue laundry soap, mentioning the particular properties, and we see the fact that this campaign says that it uses natural ingredients.
Now, pause. The Apple and Pear case, does it not, on one hand, say that if a campaign is discouraging products or sales of products from other states, disparaging those products in the eyes of consumers, or discriminating on the grounds of origin, that in those circumstances, it could amount to a measure. Yes?
Your Honor.
Right. So on the facts of this case before us, why can it not be argued that that is so?
Yes, Your Honor. Thank you for that question.
That's what you have to answer, right?
Yes,
You have to,
exactly.
because we have to deal with the facts of the case.
Yes, Your Honor.
Mhm.
Your Honors, if we look at the Apple Impaired Development case, it says that a company is allowed to mention the origin of that good, but is
Yes.
not allowed to base their campaign solely on the origin. We see in the Apple Impaired, or we see in the Safe and Clean campaign, the campaign promotes the quality of the product, saying that it's safe and it uses natural ingredients, and then prompts support for Trimagonian products, not solely on the base of its origin, but also on the base of its qualities, and which is allowed based on the Apple Impaired Development
Does it
case.
say that it is the only product using natural, it's the only soap using natural products?
It says, unlike other soap, it uses natural ingredients.
Unlike other soaps?
Yes. But
Was
not
that-
all the other soaps.
Was that accurate in relation to the claimant's soap?
Whether,
Would you say that was accurate?
whether that was accurate or not would fall within would fall within competition law, because it then would talk about the way you are allowed to promote a specific product.
And I guess you could argue that if the competition in this case also uses natural product, then they could easily mount a campaign to say that they use natural products as well.
Exactly. They could also do that. Yeah,
Please
so
proceed. Yes, thank you.
based on the Apple Impaired Development case, Apple Impaired Development Council versus KJ Lewis, 1983, paragraph 18 to 21, we can conclude that the Safe and Clean campaign did not frustrate the free movement of goods. Therefore, Trimbago's lack of actions cannot be considered a violation of Article 91 of the Revised Treaty of Chaguaramas, in conjunction with Article 79 of the Revised Treaty of Chaguaramas, of a member state to adopt adequate measures to deal with the actions of private entities to support the free movement of goods, as stated in the Commission versus France, 1997. In conclusion, it is evident that this court has no jurisdiction over the matter at hand. The actions undertaken by TPSO are purely private and have not hindered the free movement of goods. As such, this matter falls under competition law, which falls within the realm of natural competition law. We see on page 16 of the competition policy and law in the CSME that it is important to recognize that remedies for such matters are appropriately sought on a national level. Take, for instance, Your Honor, the Protection Against Unfair Competition Act of Trinidad and Tobago, Chapter 882, 36, Section 4, Subsection 2. It's a legal framework designed to address concerns relating to unfair competition that fall within the natural jurisdiction of the Republic of Trimbago. Furthermore, Your Honors, the Fair and Trade Commission of Trinidad and Tobago, as stated in Trinidad and Tobago Fair Trading Act, Chapter 81, 13, Section 5, Subsection 1A1, it stands ready to deal with anti-competitive conducts which take place in a natural economy, which deal with consumer protection within the domestic market. Therefore, it is clear that the jurisdictional boundaries of this court do not extend to this matter. We ask of this honorable court declare that the defendant did not breach Article 91 of the Revised Treaty of Chaguaramas and allow for resolution within the appropriate legal framework of the Republic of Trimbago. That is the end of my plea.
Any questions?
Thank you. No
Any
question.
questions? Thank you very much, Ms. Lindfeld. Yes, thank you. Yes, TT Distributors, you have a reply, 5 minutes. Ms. Batch, you're back with us. Please proceed.
Good morning again, Your Honors, and may it please this court. Counsel for the claimant maintains that the defendant Trinbago has breached Articles 32, Articles 82 to 84, and Articles 9 to 1 of the revised Treaty of Chaguaramas. It has already been established that the Hassans are community nationals, and the CCJ lacks original jurisdiction under Article 211 of the RTC to adjudicate matters of citizenship, and any attempt to deprive the Hassans of their validly issued citizenship without following due process would constitute a breach of natural justice. Further, the government of Trinbago alleges that the Hassans were convicted of fraud, and their names remain on an Interpol red list as convicted criminals. However, considering the global publication of the Interpol red list and the frequent travel of the Hassans between Dominica and Malta, it raises the question as to why they have not been subject to provisional arrest at the very least. It is highly unlikely that both Dominica and Malta are remiss in conducting appropriate due diligence. Instead, this allegation represents one among numerous unfounded and irrelevant claims that the defendant is levying against TT distributors, evidently aimed at obstructing the rights accorded to them under the RTC. The defendant claims they have acted in good faith. However, Trinbago's actions have not reflected good faith. Trinbago's application to the Secretary General, the subsequent misclassification by the Comptroller, and the failure to remedy the misclassification, when considered all together, does not appear to be acting in good faith. And as a result of their bad faith actions, Trinbago's misclassification should receive further consequence. Further, the defendants claim that the Republic of Trinbago is not liable for the actions of TPSO. However, the Republic of Trinbago's liability under Article 9-1-1 arises from its inaction to implement necessary or proportionate measures to mitigate the obstruction to the free movement of goods, in this case laundry soaps, by a private company. Pursuant to paragraphs 28 to 30 of the Commission Against France case, measures having equivalent effect to a quantitative restriction do not prohibit solely measures emanating from the states themselves, but also apply where a member state abstains from implementing measures to mitigate the obstacles to the free movement of goods, which are not caused by the state. The Republic of Trinbago, therefore, remains responsible even though the private party TPSO have taken the lead in restricting the free movement of goods, specifically laundry soaps, within its territory.
Miss Bash, can I just disturb you for 1 minute?
Yes.
Is there anything in particular that you heard your friends on the other side say that you would like to rebut or to address us on? Because I think that is what a reply is properly about.
No, Your Honor, we maintain our earlier position, and we believe that the strength of our argument would speak for itself.
I see. Well, complete your statement then.
Yes, Your Honor, the Republic of Trinbago therefore remains responsible even though the private party TPSO has taken the lead in restricting the free movement of goods. Further, under paragraphs 31 to 32 of the aforementioned case, Commission Against France, the fact that the member states abstain from taking action, that is, failing to adopt adequate measures to prevent obstacles to the free movement of goods initiated by private individuals on its territory, is just as likely to obstruct intra-community trade as a positive act. In addition, Article 30 of the EEC Treaty requires member states to not merely abstain from adopting measures, but in conjunction with Article 5 of the EEC Treaty, to take all necessary and appropriate measures to ensure that fundamental freedom is respected in its territory. So similarly, under Article 9-1-1 of the RTC, the defendant has a duty to not only refrain from adopting measures that constitute a quantitative restriction, but in conjunction with Article 7-9-1, it is the duty of the Republic of Trinbago to establish and maintain a regime for the free movement of goods within the CSME. The defendant also has a duty under Articles 184E and H to promote the interests of consumers in the community by adopting appropriate measures that 1. Encourage fair and effective competition practices, and 2. Protect consumers by prohibiting discriminations against producers and suppliers from other member states. However, Trinbago failed its obligations under the RTC to take all necessary and appropriate measures to ensure that the Safe and Clean campaign inaugurated by TPSO did not frustrate the free movement of community goods within the territory. The claimant once again maintains that
Ms. Baxter, how is this preventing the free movement within the territory? How is this campaign preventing free movement?
Your Honor, the campaign is preventing the free movement of goods within the community because TPSO and Trinbago by extension is creating a narrative that says, well, this is the only natural made soap in
So
Trinbago.
what does free movement mean for you then? What does free movement mean?
The free movement of goods refers to the fact that goods can be circulated within the economy freely,
So that
Sorry, circulated within the economy,
within the community.
within the community.
Yes.
So it can move from one member state to another,
Yes, without discrimination.
right?
Yes.
And I'm sorry to interrupt my brother, but was that a factor here?
Pardon? Your
Was that a factor here? The circulation of goods within Trinbago?
Your Honor, the emphasis is on the word freely here.
On the what? On the what?
Freely. Freely, the word freely.
Right.
The goods in this case are not being able to move around freely.
Why not?
Because they're being discriminated against by this campaign.
But they can be moved around freely.
they may not be bought.
Right.
Your complaint is that you're going to get hurt in the market share because the narrative is discriminatory and interfering unfairly with the sale or purchase of your product, correct?
Yes, Your Honor.
What we're both asking is that covered by what is intended by free movement under Article 91? It says, shall not apply any quantitative restrictions on the, and this is the language actually of 91.1, on the importation of goods which are of community origin. So I'm just trying for you to articulate, let's assume that we accept that the campaign creates discrimination against purchase. Let's just assume that for now. Tell us how that falls within the requirements of restrictions on the importation or movement of goods of community origin. How is that happening?
Your Honor, the restriction of the goods, the quantitative measures that are equating to this is that we are not being able to profit off of these goods that are moving freely within the community. Well, that aren't moving freely within the community in this case.
And that is what movement of goods is intended to be about, buying and selling.
Yes,
So
Your
that's how we must interpret movement. That's why you fall within Article 91.
Honor. Yes, Your Honor.
Yeah, it's not just a physical movement from point A to point B. Right?
Yes, Your Honor.
Okay, well, that's what I was trying to find, what you understood.
But Counsel, I'm still left with my difficulty that I raised at an earlier stage. As my brother mentioned, I think this section deals with the prohibition, trade liberalization, establishment of common external tariff, etc. That's part 2. And then import duties and so on, and then Article 91, quantitative restrictions. And it speaks to imports and exports. And I think consistent with the questions being asked, I wonder how this article dealing with imports and exports can avail you in this case where what is taking place is a purely domestic campaign where one domestically produced or packaged product is being supposedly hampered or discriminated against or targeted by a campaign in favor of another.
Your Honor, the soap product that TT Distributors is selling is not made in Trinidad. It's not domestic to Trinbago. My apologies. So it's not a domestic product to Trinbago. It has been made from Dominica and packaged and sold in Trinbago. So it can be considered an imported product in that sense. I'm not sure if I'm following what you're asking me as well.
I'm not sure if I am believing what you are saying. Something which the material something which is assembled here, let's put it that way, is not a local product.
Your Honor, it was packaged here, it was shaped here, but that shaping and that packaging does not constitute, or it doesn't fall under the requirements of being produced in the country. So you wouldn't consider shaping soap noodles and putting them in a plastic, making them in that country. They would just be packaging them here.
We follow your argument, and I'm told that you've run out of time, but we will certainly, in light of our questions, give you a few seconds to wrap up your reply, please, Ms. Bash.
Thank you, Your Honors. The claimant once again maintains the fact that the defendant has breached Articles 32, Articles 82 to 84, and Articles 9 to 1 of the RTC. As a result, we seek the following relief. 1, a declaration that the defendant has breached those articles of the revised treaty by failing to apply the 40% CET applicable to soap noodles. 2, a declaration that the defendant's inaction towards the Safe and Clean campaign constitutes a breach under Article 91(1) of the RTC. And 3, an order requiring Trinbago to impose the 40% CET applicable to soap noodles unless COTED grants an otherwise order pursuant to Article 83(2). Your Honors, unless there are any other questions, this is the extent of my submissions.
Nothing from me.
Nothing? Thank you. Thank you very much, Ms. Bash. And I think that brings us to the end of this morning's session. Is that right? Yes. Thank you very much to the council before us. We've appreciated and enjoyed hearing all of you. And we'll be back at what time, Madam Registrar? Is it 1 o'clock? 1 o'clock for the second session on the second team. Thank you so much. And we can rise.
All right.